really excited to introduce our guest speaker today. Our guest today is Kristen Marks. She is an author, a speaker, and a Florida wills, trust, and estates attorney. She's also the founder of My Pink Lawyer, which is a Pensacola-based estate and succession planning law firm, which helps Florida families prevent bad mistakes from happening when a loved one dies. My Pink Lawyer actually customizes estate and succession plans that help people avoid confusion about your wishes, help minimize family conflict, help make the transition of assets as simple as possible, oftentimes without unnecessary court and government intervention. And they also look for ways to minimize taxes and legal expenses. Kristen has, as I mentioned earlier, authored a book called Wise Women Protect Their Assets. It's an essential estate planning guide for smart women. You can actually order that if you're interested. It's a free book. It's a free resource to all of you on the phone. I would highly encourage it for men or women because there's some great stories in there that I think are really easy to relate to. Her website is www.mypinklawyer.com. In Kristen's spare time, she loves to spend time with her family and ride her Peloton. She meditates, practices yoga, travels, and she also has trained for ultra-distance trail running races. So without further ado, Kristen, thank you so much for being on today's call.
Thanks for inviting me, Lori.
We are excited to have you. So I'm going to kick this off question and answer style. So one of the questions that we get often from our clients when we're talking about estate planning goals is that they want to avoid probate when they die. So first, can you explain to us what exactly is probate and why would it be a good thing to avoid?
Sure. So in a nutshell, a probate becomes necessary when someone dies and they own assets in their name. And that person who died is no longer here and available to retitle or transfer their assets to their intended beneficiaries. So that's usually what prompts the necessity of a probate in the first place. And just think of it this way, it's just the process of retitling assets out of someone's name when they die into the name of whoever is supposed to inherit those assets. It is a court process, which means there is a judge involved. And anytime you get the courts involved, you can imagine it can get expensive. So a lot of folks, when they are planning their estates, one of their planning goals is to avoid probate of their assets so that they can save their family time and money in the future in the succession of the assets. And in Florida, probates are time consuming, as I imagine they are in most other states. In the simplest of probates, it might take 3 to 4 months. The most common type of probate, though, can take a year or longer. And as far as costs go, in Florida, for a smaller estate, you might be looking at $3,000 to $4,000 in probate expenses, and for the more common type of probate, you're looking at $7,000 to $10,000 in probate expenses, or more, depending on if people are fighting over what's happening with the estate. So that's why a lot of folks try to avoid probate whenever possible with their estate planning.
Perfect. So maybe you can answer this for us. So under what circumstances is probate actually necessary, and what are some of the ways that we can avoid it?
Okay, so a probate is necessary if someone dies and they own accounts or assets in their name, and there's no beneficiary associated with them and no co-ownership with another person with the right of survivorship. So the simplest way that I can describe whether a probate is needed when you pass away is to imagine 4 different buckets lined up on the table. And I have this graphic in my book. If anyone wants to order a free copy, they can do it from my website, mypinklawyer.com. And I have a whole chapter on this in the book with the graphic. But imagine on a table, we've got 4 buckets lined up, Lori. And imagine that anything that you own right now, whether it's a bank account, it's a piece of real estate, it's an IRA, it's a life insurance policy, it's your stuff in the house, it's your automobiles. All of those things live in one of those 4 buckets. Those are the only options. All those assets have to be in one of those 4 buckets. 3 of those buckets will avoid probate when you die. One of those buckets is not like the others, and it will require a probate when you die. So let's talk first about the 3 buckets that avoid probate. The first bucket is for any assets that you co-own with another person with a right of survivorship. So in Florida, it is presumed that if you co-own an account or an asset with your spouse, the presumption is that when one spouse dies, the other spouse continues to own that asset automatically. No probate is needed. There's an automatic right of survivorship. If you co-own assets with somebody other than a spouse, then the presumption is just the opposite. The presumption is that there is no right of survivorship, so when one of the co-owner dies, the surviving co-owner continues to own their interest in that asset, but the deceased co-owner's share can pass according to their will or under Florida law. And of course, it can be overridden by specific language in the titling document, whether there is or is not a right of survivorship. But if it's not addressed in the title document, then those are the presumptions, that there is a right of survivorship between spouses, that there is not a right of survivorship between spouses. So any assets in the co-ownership bucket that has a right of survivorship, when one co-owner dies, no probate needed, the surviving co-owner continues to own that asset now 100%. So that's the first bucket that avoids probate. The second bucket that avoids probate are any accounts or assets that have a beneficiary designation for them. So, for example, the most common types of these types of assets in bucket number 2 would be life insurance policies, IRAs. You can even have bank accounts where you have signed what we call a payable on death or POD form for the bank account. You can also in Florida sign a deed called a ladybird deed. And this is a special type of enhanced life estate deed where you would continue to own the property, the real estate during your lifetime, but you've essentially added a beneficiary upon your death for that property. So those are examples of assets that would be in bucket number 2, the beneficiary bucket. And oftentimes you can name backup or contingent beneficiaries as well in case your primary beneficiary predeceases you. And then the third bucket is for any assets that are owned by a trust. And with this bucket, you may pass away, but the trust that you have transferred your assets into during your lifetime has not died. And the trust document says that when you pass away, this is who is supposed to now inherit those trust assets, and this is the new person in charge of making that happen. So that's the third bucket, and it only works for assets that are actually retitled into the name of the trust or are payable to the trust by way of a beneficiary form. So those 3 buckets all avoid probate. So if all of your assets fall into one of those 3 buckets, when you pass away, no probate is going to be needed by your family in order to get the assets out of your name. Now the fourth bucket is the everything else bucket. So anything else that you might own that doesn't fall into one of those first three buckets, by default, ends up in the fourth bucket. And we call this the probate bucket. And think of this as any assets that are in your name or that you own that you don't co-own with someone else with the right of survivorship, doesn't have a beneficiary on file, doesn't otherwise pass by operation of law, which I guess could be another bucket, but I won't confuse people, and aren't owned by a trust. So for example, if I own a home and it's just my name on it, when I die, I am not here to sign a deed over to my kids, who I want to inherit my house when I die. So somebody has to be appointed to stand in my shoes in order to sign that deed over to my children, because I'm not here to do it. And that's where a probate comes in. So if my house is in that probate bucket, then a probate judge has to appoint somebody to stand in my shoes to wrap up my affairs and retitle the house out of my name to my kids. And that court-appointed person in Florida, we call that person a personal representative. They are personally representing me in wrapping up my affairs. Other states use the terminology of executor, but it means the same thing, Lori. So that fourth bucket is the probate bucket. Now, let me dispel a common myth that you probably hear, Lori, and that I hear all the time. A lot of folks mistakenly think that if they have a will, that their estate avoids probate because they have a will. That is not true.
Yeah, definitely have heard that.
Yeah. So what determines whether a probate is needed is if you have any assets in that probate bucket, not whether or not you have a will. So that probate bucket, you may or may not even have a will. But let's say there are assets in the probate bucket and you have a will. Well, what a will does is it provides written instructions to the probate judge about who you want to inherit your assets, what terms you want them to inherit the assets on, and who you would like in charge of making this happen. So it's basically you speaking from the grave to the probate judge that, Judge, when I die, any assets in this probate bucket, this is what I want to see happen. Now, you might have assets in your probate bucket and you don't even have a will. Well, if you don't have a will, you can't speak directly from the grave to the judge. So instead, the judge says, okay, this person who died does not have a will. I'm going to have to turn to state law to decide who is supposed to inherit this person's assets. And each state also has their own order of priority in terms of preference of who should be the personal representative or executor. So that's what the judge does if you die without a will and you have assets in your probate bucket. Kind of a side trail here, Lori, that I think would be of interest to your listeners here is another thing that I often hear is, if I have a will, my will controls all of my assets. Well, we already know that's not true. Your will would only control any assets in the probate bucket. But any assets that are in the first three buckets, co-ownership with rights of survivorship, beneficiary designations, and the trust buckets, those buckets take priority over the probate bucket. So you could have a will that is in direct conflict with the first three buckets. So let me give you an example. I handled a probate a few years ago, and this person died, and he had a will that was not prepared by me, I'll just preface that. And his will said, I give a third of my assets to my wife, it was a remarriage situation. I give a third of my assets to my wife, a third of my assets to my children, and a third of my assets to my wife's children. He thought he was being very fair, doing a third, a third, a third. Well, what happened when he died is that I think he owned one little account in the probate bucket. That was just in his name, which is what prompted the probate. But the majority of his assets were co-owned with his spouse. And remember, there's a presumption of a right of survivorship there. And he had assets where he had named his wife as the beneficiary. So the bulk of all of his assets passed to his wife who survived him because his assets lived in the first two buckets. And his kids were livid. They were so mad that they weren't getting a third of all of his assets, but it's because he had not structured his assets properly to carry out his intended wishes of the third, a third, a third. So anyway, long-winded answer to your question, but hopefully that helped clarify when a probate is needed and how to avoid probate in various situations.
No, I thought that was great. I think throwing the example in there really helps solidify how that could be misconstrued along the way. Another thing that I'll add that we addressed on the earlier call, but I think bears repeating on this segment right here, is the titling. You've mentioned it a couple of times, but the titling of the assets is important, but especially when it comes to the trust. And I mentioned this story earlier on the call, but one of the longest probates that I've had to work with clients through happened when we had several siblings who were trying to help Dad, who was still in okay health, actually. And Dad had a trust. They just wanted a local advisor. So somehow I inherited this client, this group of kids, or adults, I should say. And they thought Dad had done everything correct because Dad purchased the trust. But after meeting with them for the first time, it was very quick for me to see that actually none of the assets were titled in the trust. So while Dad had paid money for a trust, nothing actually was inside of it. It was like an empty box. And so we began the process of moving the assets into the trust to make sure they were titled appropriately. And unfortunately, Dad got sick at a very quick pace and passed away in the midst of that process. So now we have half the assets in the trust, half the assets that are not, and they did have to go through probate, which took quite some time. So, titling the assets, I know, is of huge importance to make sure that it reads out exactly the way that you want, especially when they trump that probate bucket.
That's right.
So I'm glad you mentioned that.
Yeah, that's the biggest mistake I see with trusts.
Yes. Same here. Speaking of trust, though, living trust, we get a lot of questions about that. So are they a good way to avoid probate? Should everyone have one?
Well, they are a great way to avoid probate. That's the third bucket that I mentioned, but they're only a great way to avoid probate if you have retitled your assets into the name of the trust. What does that mean? If you own real estate, rather than me owning my home in my name, Kristen Marks, if I had a trust and I wanted it to avoid probate through that trust, I would sign a deed retitling my house to Kristen Marks, trustee of the Kristen Marks Living Trust, or whatever my trust is called. And then I would record it. And I could do something similar with my bank accounts, my taxable investment accounts. Typically with life insurance or retirement accounts, those we would handle using the beneficiary bucket. And I could actually name my trust as the beneficiary of those types of policies and accounts when I die. So, Lori, trusts do work when they are properly funded to avoid probate. But I think your question also moved into, does everybody need a trust? And the answer is no, not necessarily. Remember, living trusts are simply one mechanism that we have at our disposal to avoid probate when you pass away. So we still have the other two buckets available. So if avoiding probate is one of your estate planning concerns, and frankly, it's not a concern for everybody. It is for most of my clients, but it's not a concern for everybody. And if we can adequately address probate avoidance through the first two buckets, co-ownership and beneficiary designations, then there's no reason to spend, in my opinion, the extra money or go to the extra bit of work needed to fund your trust, because we're avoiding probate through other means. But sometimes a living trust really is the most appropriate way to proceed to avoid probate. For example, if you have minor children or disabled loved ones that you want to leave assets to, you want to put somebody else in charge of managing those assets for your minors or your disabled beneficiaries, and a living trust is a great way to do that without having to get the probate court involved. Similarly, if you own real estate outside of the state of Florida and you pass away, well, now we're looking at two probates. We're looking at a probate in Florida because you were a Florida resident. That's your primary probate. And a secondary probate in that state where you owned real property. Because Florida courts don't have jurisdiction over out-of-state properties, a second probate would be needed in that other state. So that is definitely a factor that I consider when I am recommending or not recommending a living trust to a client. Now, a reason not to just go with a trust, Lori, would be because your neighbor has one, your brother-in-law has one, your parents have one. It doesn't matter who has one. It's appropriate for particular situations. So it may or may not be the best estate planning vehicle for you to use, but it certainly warrants a conversation.
Absolutely. And that brings up a good point. I mean, obviously, we don't all live in the same situation, and we don't all have the same stories and assets and things like that. And so we are uniquely different, and it needs to be evaluated in such a way. So can you tell us a little bit, because I know we do have a lot of blended families, second marriages, maybe even third or fourth marriages with multiple kids involved, you know, whether they be adults or young children. What are some special estate planning considerations that those type of families need to keep in mind?
Well, a lot of times I'll have a married couple come see me that want to do their planning together. That's very common, even in a blended family or remarriage situation. And it's common for this married couple to say, oh, we just love each other so much and we own everything together. We've commingled our assets. And when one of us dies, we want to give everything to the other person with no hassles. And when we both die, we agree we want everything to to pass to our collective children, his, hers, and maybe ours together. Well, the obvious problem with that is when everything passes to the surviving spouse, what's to prevent the surviving spouse from changing the plan and cutting out your kids? Well, nothing. Once you give away something to somebody, it is theirs to do with as they wish, if you've just given it to them outright. And Lori, also, this is a consideration even if it's a first marriage situation and all of your kids are your joint kids. What's to prevent your spouse from remarrying in the future if you die first?
Oh, that's a great point.
Yeah. So I see that we have this conversation too. So a few things that we can do. The first thing I do is just bring up the possibility. And frankly, I have some clients, once I bring it up, they look at each other and they're like, whatever, I'll be gone, I'm not worried about it. Okay, and that's fine. As long, we brought it up, it's been aired, that's a perfectly reasonable response. Other times, one of the clients or both will say, I totally didn't think about that. So what can we do? Well, one option would be to put strings on part of the inheritance going to your spouse. So without going in the weeds too much, basically you could leave some assets or monies in trust for the benefit of your surviving spouse. And this trust says it's for my spouse's benefit while they're alive, but when they die, this is what happens to any remaining assets in that trust. So that's one option. Another option would be if you have enough assets to do so that your surviving spouse doesn't need them all, you might carve out some monies or assets to go directly to your kids when you die, regardless of whether your spouse survives you or not. So let's say I have $1 million life insurance policy and I'm on my first marriage to my husband and we've got 2 kids. Let's say I'm concerned that if I die first, my husband, he's still young, he might remarry. And I'm concerned that everything we've worked hard to build together is going to go to this new spouse and her family, because maybe she's younger when he marries her. If I feel like I could carve out maybe some life insurance proceeds to go directly to my kids upon my death, still leave life insurance to my husband, leave life insurance directly to my kids, at least I've hedged against the risk that worst case scenario happens and everything ends up going to new spouse. At least I've guaranteed my kids got something, darn it, when I died. So that's another option. And then a third option might be my husband and I have an agreement that's drafted up that we sign off on that agrees that when we die, we are not going to change our estate plan distribution to cut out our kids. And that everything that we've built together is for our kids' benefit when we both die. My husband moving forward with new assets that he builds, he can do whatever he wants to with those assets, but what we've collectively built together is for the benefit of our kids. And our kids become the third-party beneficiaries of that agreement. So that's a third way that we can handle it. And we just explore those options when I'm meeting with clients.
Perfect. Well, Kristen, we've got about 2 minutes left. I'm wondering if you could fairly quickly answer this question. So is estate planning a one-and-done deal? And if not, how often and under what circumstances should someone maybe review their plan?
A great question to close on, Lori. And no, your estate planning is not a one-and-done deal. It's not a set it and forget it like that old rotisserie chicken cooker commercial. My rule of thumb with clients is every 3 to 5 years, you should be reviewing your plan with your estate planning professional, talking it through. Inevitably, your life will have evolved within that time. And maybe after the conversation, you've decided together, you know what? We're good. We don't need to change anything. Great. I'll see you in another 3 to 5 years. Certainly, if you have a major life event in the meantime, and we all know what those are when they happen to us, marriage, disability, a death, retirement, incapacity, moving to another state, those should all also prompt a review of your estate plan. Same with your financial planning. It's not a one and done deal. Your financial plan needs to evolve over time with your changing circumstances.
Yeah, no, that's perfect. Yes, we try to encourage our clients every 18 to 24 months. They like to be reviewing their plans. Actually, just finished this last month working with quite a few people on those updates, and we'll have a few more to do. But life does change. Well, Kristen, we are just about out of time right now, so I want to thank you again. I want to encourage people to go to your website at www.mypinklawyer.com and get your book, or to reach out to Chris and I with any further questions. We'd be happy to continue to be a resource.